Right.
The 36th District Court in the state of Michigan is now in session. The Honorable Donald Coleman is presiding. While court is in session, there will be no talking, sleeping, chewing of gum, or reading any materials. Thank you.
This is case number 24159-266. This is Citibank versus Eugenia Jones. The matter is before the court, settled for a first hearing of status conference. The court is in receipt of the answer. The record should reflect that the complaint in this matter alleges damages in the amount of $2,269.55. Your appearance for Citibank, please.
Yes, Amy Colston.
Go ahead, put your P number, Ms. Colson, please.
Of course, Your Honor, a P64742.
All right, thank you, Ms. Colson. Good morning to you. I'm looking now for Ms. Jones, Eugenia Jones. If you're on the Zoom, please say something at this time.
Yes, I'm here. I'm present.
Good morning to you, Ms. Jones. Ms. Colson, any discussions regarding this matter that you want to bring to the court's attention at this time?
Yes, Your Honor. At this time, I'm showing a balance due of $1,669 plus costs on this case. I have spoken with Ms. Jones, and we have agreed to a consent judgment for that amount, plus reasonable costs. Ms. Jones has agreed for us to sign the forthcoming order on her behalf, and she will be making payments of $250 a month starting March 15th, with subsequent payments due the 15th of the month thereafter. And upon default, we would file an affidavit of non-compliance, but it doesn't sound too likely in this matter, Your Honor.
All right, and give me the principal amount of the judgment again. You said 16. Go ahead, ma'am.
69.
1669. No cents.
Correct.
All right. And so, Ms. Jones, you've heard the recitation of the agreement that has been reached by the parties, I presume, and that is that consent judgment would enter for $1,669 plus court costs, and that would apply in this matter. Then the agreement is that now will be paid towards March, and as long as compliance is had, then no further actions will be taken. If compliance is not had, then the affidavit will be filed with the court, setting aside the payment agreement, and would allow for collection on the judgment. Is that your agreement and understanding, Ms. Jones?
Yes.
And you've given Ms. Colson the permission to go ahead and affix your name to the consent judgment, given that it's on the record now. Is that correct, ma'am?
Yes, I do.
All right. Thank you, Ms. Jones, and thank you, Ms. Colson. Ms. Colson, you may proceed accordingly and present the judgment to the court. I do have notes on it. I will sign the judgment consistent with the terms as agreed upon by the parties, and then we'll
Thank you, Your Honor. Excuse me.
All the best to you. All right.
Thank you. You too.
Thank you.
The court now calls 24159-450. This is Calvary SPV1 LLC versus Antonio Alvarenga. Matter is before the court, set on for a pre-trial conference. Matter was before the court on the 7th of January. This is the return date. Your appearance for Calvary, please.
Yes, Your Honor. Christopher Royce, P49102.
Thank you, Mr. Royce, and good morning to you.
Good morning.
I'm looking for Antonio Alvarenga. If you are on the Zoom or someone representing Mr. Alvarenga, say something at this time.
Yes, my name is Stanley Bynum. I'm representing Antonio Alvarenga.
Thank you, Mr. Alvarenga. Good morning to you, sir. Counsel, as an officer of the court, any information you wish to bring to the court's attention at this time, sir?
Well, Your Honor, Mr. Alvarenga he had requested a valid verification of debt, which was sent out. I think he wanted to see that before he made any type of settlement offer. It was sent out on Thursday. I would just ask for a motion for summary judgment date, and he can review it, and hopefully we can settle it before any hearing on the motion.
All right, Mr. Alvarenga, anything relevant to this hearing that you wish to bring to my attention at this time, sir?
No, I'll be just waiting on the validation.
All right, got it, sir. All right, so what I'm going to do is I will set a date that will allow time for the filing of any motion that the parties individually or respectively wish to file, and we'll set a date for hearing the same. So at this point, I'm going to set the motion hearing date for April the 23rd. April 23rd, Wednesday, April 23rd. Motion set it for hearing on that date at 9:45 a.m. That's 4/23/25 at 9:45 a.m. That'll be the motion hearing in regard to this matter. I'm just checking on my thing. Actually, I'm going to be away that week, so let me change that right now. That's going to be 4/28/25 at 9:45.
Great. Thank you, Your Honor.
All right, good day to both sides.
Judge, excuse me, Judge, before they go, can I have the name of the person that's speaking for Mr. Alvarenga, or is that Mr.?
That is Mr. Alvarenga. You're Antonio Alvarenga that's talking. Is that correct, sir?
I think someone else.
No, it's Stanley Bynum.
No.
What's your name?
Where is Mr.
He's there on the screen, but it's someone else speaking for him.
Stanley Bynum.
Okay, wait a minute. We can't do it that way. The only person that can speak on this case is Mr. Alvarenga. Where is he? Where's Mr. Alvarenga?
Raise your hand, sir.
Okay, Mr. Alvarenga, what do you wish to tell me, sir?
I don't think he's speaking.
I was translating for Mr. Alvarenga. I did it last time on the first hearing.
Yeah, that would have been an error. Are you a certified interpreter?
No, not certified.
No, you can't do that. I appreciate your effort. You can't do that. What language does Mr. Alvarenga speak?
Spanish.
Okay, Mr. Alvarenga, I'm going to have a Spanish-speaking interpreter here in the court for you on the next court day. So we'll set this over with the new date. I'll send a new date out, and I'm ordering a Spanish-speaking interpreter to assist you at that time. We have to have someone that's a certified interpreter to be a part of this process. So that will be on the next date. That's the 28th of April 2025. Now, sir, what is your name that was talking on the Zoom? Tell me your name, sir. What's your name, sir? Go ahead and tell me who you are. You were speaking for Mr. Alvarenga. What's your name?
Stanley Bynum.
All right. Thank you, Mr. Bynum. All right. Thank you for your effort, but we have to have somebody certified. Good day to you, sir. Thank you.
Thank you.
I got some special notes on that.
You can leave, Mr. Bynum.
You all set? All right. Madam Reporter, this is case number. This is case number 24-251524. This is Beverly Parker versus Princeton Management. Matters before the court settled on for a status conference. The record should reflect that this matter was initiated in the small claims division of this court. It was removed to the general civil division by counsel for the defendant on 12/9/24. Are your appearance for any party that has an attorney, your appearance attorney, go first, please?
Carolyn Cohen, P49391, appearing on behalf of the plaintiff, Your Honor.
All right,
I'm sorry, on
thank you.
behalf of the defendant, I apologize.
Thank you, counsel. And that's Princeton Management, correct?
Yeah, yes.
All right. Do I have Beverly Parker on the Zoom as well?
Yes, I'm here.
All right. Good morning to you, Ms. Parker.
Thank you.
So I see that this is a complaint for some $2,380, and it's been removed here to the general civil division. Have the parties had any occasion to talk about this at all, Madam Counsel, as an officer of the court?
Yeah, Your Honor, we went into a breakout room, but there was no resolution. So we're looking for some discovery and some summary disposition dates.
All right. Thank you very much, counsel, for that update. Ms. Parker, anything you wanted to bring to my attention at this time?
Well, I would like to do discovery also. I cannot afford an attorney. I started this in small claims court for that reason, but they moved it here so they can extend it and do all these things. So how do I get maintenance reports and that kind of thing? Because that's what I want.
All right. So I am going to open discovery in this matter and allow a 60-day period for the same. And by the way, removing the matter to the civil division is a process that is allowed by the court rules, and either party could remove it. Even the person who started it, small claims, could decide that, well, I want to move it to the general civil division. So either party could do it that way. Now that it's in front of me, I'm going to set up a schedule for discovery. If there are items that you want to discover, all you need to do is put in writing the items that you want in discovery, and to send that request in writing to the other party. And they will have 28 days from the time that you submit your request in writing to respond. All right. So the return date in this matter is going to be, just one moment here. Yeah, the return date is going to be the 12th of May. It's going to be 5/12. 25 at 9:30 a.m. That date is set as a pretrial conference. That date will be in the scheduling order. I'm going to send a scheduling order out to both sides. That scheduling order will say that discovery is open through May 5th, 2025. It will also say that that is the date upon which the parties return in front of me at 9:30 a.m.
Thank you.
Right,
Can summary disposition motions be heard that day too?
Motions that are timely filed can be heard on that day. Follow the scheduling order pursuant to paragraph number 6. Although I'm not setting formal dates for filing motions, if you follow paragraph 6 on the document that I'm going to send you, you can certainly file a motion and set it for hearing on the 12th of May. And the only reason I mention it the way that I do is if discovery is such that you're not able to get the motion filed before the end of discovery, there will be a motion hearing date that I'll set at that time. So, but so my paragraph number 6 will explain it, that if early in the case you discover that I've got enough to file a motion, paragraph 6 gives you the procedures to follow that. If, however, you finish discovery and after discovery you say, I'm going to file a motion, I will set a subsequent date for that on the 12th.
Okay,
All
thank
right.
you so much.
Okay.
I wish to get a document from me in the mail in the next few days. This is called the scheduling order. You'll receive that in the mail. Good day
Okay,
to both
thanks. Have a good day.
Day to you, Ms. Farmer. Good day, Ms.
Thank you.
All right, the court now calls case number 22-187-309. This is Eagle Mark Savings Bank versus Penelope Yolanda House Hutchinson. That is before the court on a motion for seizure of property. The record should reflect in this matter, that this case was instituted in 2022. A judgment was entered by default in this matter. And I believe that this matter was transferred. That's right. All right, your appearance at this time for Eagles, Mark, please.
Yes, good morning, Your Honor. Ian Redmond, P70599, on behalf of the plaintiff, Eagle Mark Savings Bank.
All right, thank you, counsel. And I'm looking to see whether or not Ms. Hutcherson, House Hutcherson, is on this Zoom. I don't have any indication that she is here. So, counsel, you may proceed at this time. You've followed the various due diligence as it relates to notification on the seizure or any of those items. Go ahead, talk to me about that.
Yes, thank you, Your Honor. As you noted, this case was filed back in 2022. We did receive a default judgment in this case back on, let me see here. Yes, back on August 9th of 2022. Since then, we have tried to work things out. We have attempted to seize the property, etc., and, you know, trying to locate where this property is because it is the collateral of the loan that we had given. We are now in the process of trying to get possession of that collateral. We did notify the defendants of today's hearing by a notice that was sent out on January 31st. The notice from the court was also sent out on February 11th. So they should have plenty of notice for today's hearing. At this point, we are asking for an order allowing us to seize the property. We can submit a proposed order.
All right, thank you, counsel. I've reviewed, as you say, in review of the file, the court knows that notes the entry of the judgment on 8/9/22 for $20,020. I also note that there has not been any efforts by the defendants in this matter to set that aside or to challenge the veracity of the same. Given those factors, together with the fact that today's hearing was noticed to the parties at their last known address, and parties have not appeared, defendants have not appeared regarding this matter. For that reason, the court will allow the order procedure or interim order procedure allowing for the seizure of the subject property. All right, so counsel, you may submit your order.
Thank you so much, Your Honor. Have a great day.
Likewise to you. I know it's too ugly. I'll play it fine.
Okie dokie.